Good morning. I'm Gary DeWaal, and this is Bridging the Week for October 23rd to 27th, and today is October 30th, 2017. A subsidiary of a U.S. bank was fined the equivalent of $45 million by the UK Financial Conduct Authority for violating European requirements related to the mandatory reporting of exchange-traded derivative transactions to trade repositories. Separately, a jury found the former head of global foreign exchange cash trading at a large international bank guilty of front-running a customer's $3.5 billion foreign exchange transaction, while a co-head of the U.S. Securities and Exchange Commission's Division of Enforcement indicated that review of the quote-unquote digital ledger technology space will be a focus within the division's cyber unit. Next week is Halloween, and the first Smart Financial Regulation Roundtable in Washington, D.C., co-sponsored by the Mercatus Center and George Mason University and the Institute for Financial Markets, where I am moderating a panel on enforcement. So I can trick and treat and get down in D.C. in time. Let's get started. Merrill Lynch International consented to the imposition of a fine of 34.5 million Great British pounds, over 45 million US dollar equivalent, by the UK Financial Conduct Authority for not making certain reports of exchange-traded derivative transactions to trade repositories as required under the European Markets Infrastructure Regulation. Specifically, FCA alleged that from February 2014 through February 2016, Merrill Lynch, an indirect subsidiary of Bank of America, failed to make 68.5 million required reports of the market-side leg of certain exchange-traded derivative transactions involving non-European Union third-party brokers. According to FCA, under relevant EMIR rules, when Merrill Lynch acted as an intermediary for a customer in connection with each exchange transaction, the firm was required to report to a trade repository both its transaction with its client as well as its transaction with the exchange. FCA said that the firm's failure was attributed to a static data table within the firm's system that did not properly flag some non-EU third-party brokers as necessitating the generation of a synthetic market side for reporting. FCA alleged that Merrill Lynch's errors were not detected earlier because its reporting function was inadequately staffed. It failed to undertake any quote-unquote appropriate testing of its reporting between February 2014 and October 2015, and conducted only an inadequate manual test in October 2015. This was the first enforcement action brought by FCA alleging a trade reporting breakdown in connection with exchange-traded derivatives under European regulation. Mark Johnson, the former head of global foreign exchange cash trading at HSBC Bank, was found guilty by a jury of fraud for front-running a customer's large foreign exchange trades in 2011 following a trial in a federal court in Brooklyn, New York. According to the criminal complaint filed by the U.S. Attorney's Office in Brooklyn, Mr. Johnson, along with Stuart Scott, former head of FX cash trading for HSBC for Europe, the Middle East, and Africa, conspired to trade on information confidentially provided to HSBC by Karen Energy, a client that planned to sell part of its interest in an Indian subsidiary for $3.5 billion and then convert the sale proceeds to British pounds for distribution to its shareholders. According to the U.S. Attorney's Office, HSBC profited by approximately $8 million as a result of its execution of the XX transaction for the company, including from defendants' allegedly illicit conduct. Mr. Johnson, a British citizen, is expected to file a motion to set aside the verdict by no later than December 1st. And finally, Stephanie Avakian, one of the new co-directors of the Securities and Exchange Commission's Division of Enforcement, indicated that protecting retail investors and addressing cyber-related issues will be priorities of the division going forward. She cautioned, however, that the division's, quote, enhanced retail focus, end of quote, will not diminish the division's activities to combat financial fraud or, quote unquote, policing Wall Street. Ms. Avakian indicated that the division will also focus on, quote unquote, distributed ledger technology space through its cyber unit. This is because, said Ms. Avakian, quote, like many legitimate ways of raising capital, the popular appeal of virtual currency and blockchain technology can be an attractive vehicle for fraudulent conduct. End of quote. I continue to believe that the SEC and CFTC must sooner rather than later address potential overlap in their jurisdiction to avoid inhibiting development of cryptocurrency ecosystems. Ideally, state regulators should also be part of this discussion. A current private lawsuit in New York challenging New York's BIT license requirements may accelerate this discussion. I have details on my blog site. Check it out. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Have a great week and enjoy trick-or-treating. Until the next edition of Bridging the Week, ciao.